In poker, there's a move called buying the pot. This is when one person makes a very large bet in an attempt to discourage others from continuing the hand. But what if we're not talking about poker? What if we're talking about permit fees for the use of your own land? Well, that's exactly what George Sheetz sued the county of El Dorado, California for. So we'll look at that case next on the Constitution Study.
Neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution, teach the rising generation to be free. I have this kind of reaction every time I hear people talk about building permits. My wife loves these home improvement shows, and sometimes I'll watch them with her, and well, I see permits being used for such crazy reasons. They drive me nuts. But what seems to have happened in El Dorado, California, well, takes this to a whole nother level. And you can find out more about this case, including the links I use for my sources, at the website constitutionstudy.com. I'll talk more about the website and some other ways you can support the work that we're doing here at the end of the episode. But for now, let's take a look at this case of Sheetz versus the county of El Dorado, California. How many of you have built a house or other building? Or maybe you watch those home building or home improvement shows on TV. Now, if either is true, you're probably familiar with the idea of building permits. Well, I have many issues with the way these permits are frequently used. The case of Sheetz versus County of El Dorado, California, points to the use of excessive fees to control how you use your land. The question this case brings to the Supreme Court revolves around the takings clause of the Fifth Amendment. As a condition of receiving a residential building permit, petitioner George Sheetz was required by the County of El Dorado to pay $23,420 traffic impact fee. The fee was part of a general plan enacted by the county's Board of Supervisors to address increasing demand for public services spurred by new development. The fee amount was not based on the cost of traffic impact specifically attributed to Sheetz's particular project, but rather was assessed according to a rate schedule that took into account the type of development and its location within the county. Sheetz paid the fee under protest and obtained the permit. He later sought relief in state courts, claiming that conditioning the building permit on the payment of a traffic impact fee constituted an unlawful extraction of money in violation of the takings clause. In Sheetz's view, the court's decision in Nolan v. California Coastal Commission and Dolan v. City of Tigard required the county to make an individualized determination that the fee imposed on him was necessarily to offset traffic congestion attributable to his project. The courts below ruled against Sheetz based on their view that Nolan and Dolan apply only to permit conditions imposed on an ad hoc basis by administrators, not to a fee like this one imposed on a class of property owners by board-enacted legislation. So we start with two interesting questions to consider. Shouldn't a traffic impact fee be based on the impact to traffic? Or does an exorbitant fee amount to a taking under the Fifth Amendment? Mr. Sheetz claimed before the court that it was not the fee that was the problem, but how the county determined what the fee should be. This was not based on the law, but on previous opinions from the court. Previous courts held that the Supreme Court precedent cited did not apply. This court did not agree. Held, the takings clause does not distinguish between legislative and administrative land use permit conditions. Before we get into the details of the case, I once again found a very disturbing fact about this case. The question presented to the court was not based on the Constitution or United States law, but on court precedent. This means that, once again, courts are making decisions not based on law, but based on their predecessors' opinions. This shows that we no longer have courts of law, but courts of precedent, which means we are no longer a nation of laws, but of opinions, since any judge can come to any decision he or she wants based solely on their opinion. It also means we are no longer a constitutional republic, because people believe laws can be overturned by unelected judges, who are rarely held accountable for their bad behavior on the bench. Let's look at the takings clause Sheetz claims was violated and see if it applies. Nor shall private property be taken for public use without just compensation. Is charging a fee to obtain permission to build taking private property for public use? In general, I would say no, but this case is unique. The purpose of this fee was to address increasing demand for public services spurred by new development, which would be a public use. However, the takings clause only allows one remedy, just compensation. Now, when the property being taken is a person's money, what compensation can be just? The only one I can think of is the return of the fee, which doesn't make a whole lot of sense. Now, some may argue that since taxes will be collected on the new residents, which could be used to not only maintain but update infrastructure, an additional fee is unwarranted. Still, that would not be a taking under the Fifth Amendment. So the court has held that the takings clause does not distinguish between legislative and administrative land use permit conditions. To me, it seems quite obvious that it doesn't deal with land use permitting at all, since it's not a question of taking land for public use, but exercising control over that land. So are there any protections against abusive permitting fees in the Constitution? Yes. Just because a traffic impact fee was not only exorbitant, but used for more than just traffic impact, doesn't mean Mr. Sheetz's constitutionally protected rights were protected. As with many takings clause cases, what we really have here is a violation of the due process clauses, plural. Starting with the Fifth Amendment, we read, "No person shall be deprived of life, liberty, or property without due process of law." Now, the most obvious deprivation Mr. Sheetz encountered was the deprivation of his property, namely his money, but that's not all. By requiring that Mr. Sheetz receive a permit or permission to build on his own land, he was denied the use and benefit of that property. Before we get to the question of due process, there's another clause we have to deal with, this time in the 14th Amendment. "Nor shall any state deprive any person of life, liberty, or property without due process of law." Since the county of El Dorado is a subdivision of the state of California, they too are subject to the 14th Amendment, which leads to the question, when the County Board of Supervisors enacted their general plan, which included this fee structure, did they do so with due process of law? Due process is defined as an established course for judicial proceedings or other governmental activities designed to safeguard the legal rights of the individual. Is requiring a permit to build on your own property a governmental activity designed to safeguard the rights of an individual? Possibly. See, if the requirements for a permit are to ensure the safety and rights of others, then yes, because their individual rights matter as well. Does requiring a fee for the impact your building will have on neighborhood traffic protect the rights of an individual? Again, possibly. For example, if you are building a single residence, the impact on traffic should be minimal. If, however, you're building a development with multiple homes, that traffic impact would be larger and may require the county to build or upgrade roads to support the new traffic. Does it protect your rights to be required to pay a fee not based on the impact your project would have on the actual traffic, but based on some rate schedule cooked up by the county? I don't think so. While the question before the court was the appeal of lower court decisions that the precedent cited didn't apply because of how the fee was imposed, Justice Barrett wrote in her decision, "The court's decision in Nolan and Dolan addressed the potential abuse of permitting process by setting out a two-part test modeled on the unconstitutional conditions doctrine. First, permit conditions must have an essential nexus to the government's land use interest, ensuring that the government is acting to further its stated purpose, not leveraging its permitting and monopoly to exact private property without paying for it. First, the condition for issuing a permit must have an essential nexus to government's land use interest. While I'm not sure about other courts' precedent, by limiting permitting power to government's interest in land use, that should extend no further than the impact on both public and neighboring property. But there's more. Second, permit conditions must have rough proportionality to the development's impact on the land use interest and may not require a landowner to give up or pay more than is necessary to mitigate the harms resulting from new development. Second, these permit conditions include the fees they charge, and that they must be roughly proportional to the impact on the land use, meaning in this case the actual traffic impact of Mr. Sheetz's building project. While the court pointed out these limitations on permitting process, the justices had to deal with the actual question presented to them. As the parties now agree, conditions on building permits are not exempt from scrutiny under Nolan and Dolan just because a legislative body imposed them. whether a permit condition imposed on a class of property must be tailored with the same degree of specificity as permit conditions that targets a particular development is an issue for the state courts to consider in the first instance, as are issues concerning whether the parties' other arguments are preserved and how those arguments bear on Sheetz' legal challenge. Yes, El Dorado County's requirements for building permits can be reviewed under Nolan and Dolan, but the question of the specificity of those conditions are really an issue for state courts, not federal. For this reason, the court vacated and remanded the decision back to the California Court of Appeals for further consideration. So why did I decide to review this case? Well, first, it brings to light something I've been seeing more and more of at the county level: the use of permitting processes as a means of dictating to people what they can do with their own land. As I've stated before, using permitting to help ensure that the building projects do not deprive others of their rights is justifiable. However, the permitting regulations, along with their zoning and building counterparts, have become more about controlling what people do with their own land than protecting the actual rights of others. This is one of the reasons why it's so important to be focused on what your local governments are doing. They are more likely to infringe on your rights than the federal government. Now, whether it's excessive fees or just onerous regulations, that attempt to dictate to you what to do with your property because of what someone else thinks, these deprivations of property violate the Constitution of the United States, and almost certainly the Constitution of your state as well. The fact that attorneys focus on the takings clause rather than the due process clause not only shows the failure of our legal education system, but why it's so important that you know the Constitution and are prepared to defend and assert your rights for yourself. Because there's no guarantee that your attorney, much less the courts, actually knows what the Constitution says. So again, an interesting case you probably didn't hear of, with an interesting question that led to an actually more interesting discussion. The question before the court really was just, under their precedent, could the courts review permitting fees established by a legislature as opposed to an administrator, which was an interesting question. But far beyond that, the impact of permitting and their fees and when they are legitimate and when not is really a question that should be ongoing. Because regardless of where you are, there's probably somebody infringing on your rights. I've been recently getting more involved in my county government, my county legislature, and I've found more examples of attempts to infringe on people's rights because of what other people think. You may have issues like that in yours, which is why I suggest you get engaged. Go to a county commission meeting, meet your county commissioners, meet your county mayor, talk to them, ask them what are the urgent issues in the county, and then do a little follow-up, do a little research. That's what I've been doing. You see, being a good citizen isn't just worrying about Washington, D.C. or 1600 Pennsylvania Avenue. It's about your backyard. It's about your neighbors. It's about your community. It's about being involved in local and city government. So I encourage you to do so. And if you come up with an interesting case or an interesting situation you'd like me to review, maybe even here on the website or on the video, hey, you can always reach out and ask. Just go to constitutionstudy.com/questions, ask your question, and ask that I review it here on the Constitution Study. Now, if you'd like to support the work that we're doing here, and believe me, we can use the support. I don't take a salary here. Everything comes out of my pocket. Well, first thing you do is go to constitutionstudy.com/shop. I sell books, I sell T-shirts and mugs and other little tchotchkes, and all the profits go to help keeping the Constitution Study going. If you'd just like to donate, there's a spot there where you can donate, either a one-time or recurring donation just to help keep the Constitution Study going. It certainly would help. You can also help by working with our sponsors. For example, I found this great little class called The Miracle of America, and I made a deal with the owners. You see, if you're a Constitution Study listener, you go to constitutionstudy.com/1776 study guide. That's the numerals 1776 study guide. You go to a custom landing page where you can not only read up about the class, but you can sign up for a lesson absolutely free. It's a lesson on God's natural law. You get the downloadable study guide, you can watch the video or listen to the audio absolutely free. Now, if you like that lesson, you'd like to find out more, well, you can sign up there for the entire course, and that's just $17.76, which is not a bad deal. You can also support us with your cell phone. Patriot Mobile is America's only Christian conservative wireless provider. They give you great service, 4G and 5G coverage across the whole country. They got great US-based customer support. Best of all, they don't support organizations that are trying to deprive you of your rights. They support organizations that are trying to promote your rights, including, by the way, the Constitution Study. So if you go to patriotmobile.com/Constitution, you can find a plan that works for you. You can also use the code Constitution at checkout to get free activation. Best of all, not only do you get great cell phone service and great customer support, but a portion of your bill will come here to the Constitution Study to help keep us up and running. So it's a great way to support the work that we're doing here. Again, that URL is patriotmobile.com/Constitution, and don't forget the code Constitution at checkout to get free activation. Now, if nothing else, I would hope that you would do your part and share these links, share these episodes, the stories, the articles I write. Share this information. Share it with friends and family. Share it on social media. Share it wherever you can. Because the act of sharing helps get you from being a passive acceptance of information to becoming active in your community and active in protecting your rights. And that first step is always the hardest, but it's also some of the most rewarding, just sharing this information. And by the way, it'd be really helpful if you came back next time and maybe brought a couple of friends the next time we meet here at the Constitution Study.
Love your neighbors and have a few good friends.